All right, today we're going to dig into a case from Gilbert, Arizona that, on the surface, might seem like a small neighborhood squabble. But trust me, it has huge implications for anyone living in a community with shared rules. It's a fascinating story about a heated dispute, a stalled election, and a single, mysterious document that's been hiding in plain sight for over 2 decades. So this quote from homeowner Jesse Freeman, it just drops us right into the middle of the chaos. I mean, can you imagine? You're at your annual HOA meeting, things are moving along, emotion is on the floor, and then suddenly the board just ends the meeting. That's exactly what happened here, and it all boiled down to a fundamental disagreement over the rulebook. Okay, so let's set the scene. It's January 16th, 2024, at the Millett Ranch HOA's annual meeting. The main event, the big thing on the agenda, was electing new board members. Pretty standard stuff, right? But before a single vote could be cast, the entire process just slammed into a brick wall.
Now, to really get what's going on here, we need to talk about this one crucial word, quorum. It's a simple idea, really. It just means you need a certain number of people to show up to a meeting, either in person or by proxy, for any official business to be valid. No quorum, no votes. Simple as that.
And here's the problem laid out in black and white. According to their bylaws, they needed 126 votes to have a quorum and hold the election. But that night, they only had 89 votes in total. That's a pretty big gap. So the meeting was dead in the water, right? End of story? Well, not quite.
And this is where the story gets really interesting. See, one homeowner, this Jesse Freeman, believed there was a rule for this exact situation. He pointed to this obscure document, something that was supposedly passed all the way back in the year 2000. And here it is, the document at the heart of this entire mess. It's an alleged amendment to the bylaws from over 2 decades ago. But get this, it wasn't signed, it wasn't officially sealed, and yet there it was, sitting on the HOA's own website, listed right there with all their other governing documents. So, here's why this one piece of paper was such a big deal. The original bylaw was strict. You needed a 25% quorum for all meetings. That's the 126 votes they couldn't get. But this supposed amendment, it was like a secret back door. It said if the first meeting fails, you can hold a second one where the quorum drops all the way down to just 15%, a much, much easier target to hit.
And this really boils down to the one central question that pushed this whole thing into a legal battle. Is this document a legitimate, binding rule that the HOA should have followed? Or is it just a digital ghost, a historical artifact with no real power?
Okay, so let's move into the hearing itself and see how this all played out. This is where both sides had to lay their cards on the table and make their case in front of an administrative law judge. So first up is the petitioner, Mr. Freeman. His whole case was built on one idea, proving that this 24-year-old document was the real deal, and that the board was totally wrong to ignore it.
And his evidence, it seemed pretty strong at first. First, he's basically saying, hey, it was on your official website. What was I supposed to think? Then he shows that it wasn't some new thing. Digital records prove it was scanned into their system way back in 2004. And to top it all off, the text right on the document itself says it was approved by membership. Seems like a slam dunk, doesn't it?
But then the HOA's lawyer comes back with this really surprising argument. He basically says, look, we wish this document was valid. A lower quorum would make our lives so much easier. He argued that the only reason they were fighting it is because they had absolutely no proof it was ever legally adopted in the first place. And the HOA's case was pretty simple, but really powerful. First, the document has no signatures. Second, there's no paper trail from that 2000 meeting. No minutes, no ballots, nothing. But their strongest point was this. In the 24 years since it was supposedly created, the HOA has never once used this rule. And for the final twist, they pointed out that even Mr. Freeman himself didn't use it when he was on the board and they couldn't make quorum. So, the judge has heard from both sides, seen all the evidence, and is ready to make a final call that really gets to the bottom of this whole mess. And the verdict is, the petition was denied. The judge sided with the HOA. But hang on, because the story doesn't really end there. The why behind the decision is actually the most important part of this whole thing. First, the judge said the burden of proof was on Mr. Freeman. It was his job to prove the document was legit, not the HOA's job to prove it wasn't. And without things like meeting minutes or signed papers, he just didn't have the hard evidence to back it out.
Now, this next point is absolutely critical, especially today. The judge ruled that just because something is posted on a website, even an official one, that doesn't make it a legally binding record. Just putting a file online is not proof that the proper process was followed. And then came the final blow. The judge argued that even if you pretend the document is valid, the language in it isn't mandatory. See, it says a second meeting shall require a 15% quorum, but it never says the board must hold a second meeting. It describes a possible situation, but it doesn't give a direct order. In the eyes of the law, that little difference is everything.
So, a neighborhood dispute in Arizona is over. Why should we care? Well, because this small case actually offers some really powerful lessons for anyone who's part of an HOA, a condo board, or really any kind of member-run group. So here are the big takeaways. First, official records are king. A properly signed, dated, and filed document is worth 1,000 unsigned PDFs on a website. Second, words matter a lot. The tiny difference between a word like shall and must can be the difference between winning and losing a legal fight. And finally, and this is maybe the biggest lesson of all, governance is a group effort. The whole reason this conflict even started was because not enough people showed up to participate. Which leaves all of us with one final and kinda unsettling question. Are you sure the rules you think you're living by are the ones that are actually in force? It might be worth taking a closer look at your own community's documents, because you really don't want to discover the truth in the middle of a fight.